All right, we will call the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Harris. Here. Senator Dondale Loop. Here. Senator Orenshaw. Here. Senator Wynn. Senator Hansen. Here. Senator Krausner. Here. Senator Stone. Here. Chair Scheibel.
Here. Please mark those senators present who are not yet here present when they do arrive. We have just one bill on for hearing today. That is AB 227. We will get right to it. Come on up whenever you're ready. I'll now open the hearing, to be clear.
I can, but no. Good afternoon, Chair, Vice Chair, Committee. Thank you for hearing Assembly Bill 227. I'm Leslie Cohen, representing Assembly District 29. Joining us virtually is Stephanie McDonald, who rejoined the staff of Legal Aid Center as the directing attorney at the Family Law Self-Help Center in 2013. In this position, she oversees operations at the Family Court Self-Help Center, providing information for Ms. McDonald first worked for Legal Aid in 2010 as the bankruptcy facilitator. She also served as a law clerk in family court for the Honorable Matthew Harder and the Honorable Sandra Pomerantz. And then with us in Carson City is Jonathan Norman, representing the Nevada Coalition of Legal Service Providers, which includes Legal Aid Center of Southern Nevada. Out of law school, Mr. Norman worked as a legal aid attorney on the Navajo Nation. In 2017, he moved to Las Vegas and took a position representing foster children with the Children Attorney Project at the Legal Aid Center of Southern Nevada, and eventually became the lead attorney on Legal Aid's education advocacy team before moving into policy full-time. AB 227, it's a domestic relations bill, but for me, it's a real kitchen table issue for our constituents. It's a way for our constituents, when they're dealing with domestic relations issues, to have a better, easier, less adversarial way to move their families through the court system. And with that, I will turn it over to Mr. Norman.
Thank you, Chair, members of the committee. Jonathan Norman, Nevada Coalition of Legal Service Providers. And the Legal Aid Center of Southern Nevada is the biggest member in our coalition and operates the Family Law Self-Help Center. So to give you some context, Ms. McDonald and her team help about 80,000 people every year who come in with a variety of domestic issues, from divorce, custody, and so they're a pretty big operation. A lot of people are more familiar with the Civil Law Self-Help Center, where we handle the evictions, but the Family Law Self-Help Center is a separate self-help center that just deals with family court issues. The bill creates joint petitions for annulments and for child custody. And the reason that's important for the Self-Help Center is they're providing forums and helping people with the next step in what they need to do. And where people are getting along enough that they can work on a collaborative joint petition, we don't need to artificially create an adversarial process where one person is being served a petition and having to respond. And so that's the genesis of this bill. And with that, I'm going to turn it over to Ms. McDonald to walk the committee through the bill. Thank you.
Hi, good afternoon. Stephanie McDonald for the record. I'm here on behalf of the Legal Aid Center of Southern Nevada to present AB 227 to you. As you've heard, family court is a place where people often come a little too often when family crises happen. It's estimated that roughly 70% of litigants in family court are handling their case on their own without the assistance of counsel, because many simply can't afford an attorney when crises strike. So that is where I and my team come in. I operate the Self-Help Center in Clark County, Nevada at Family Court. My team and I assist, as Jonathan said, roughly 80,000 people per year. And most of those people find the court process to be pretty overwhelming and bewildering once they get involved in it. Most of the cases that are coming into the family court involve divorce, child custody, and annulments. Although many litigants disagree about how to resolve these issues, there are also many litigants who've already done the work to figure out mutually agreeable terms to finalize their issues. They just want the court to go ahead and grant an order that formalizes what they've already agreed to. Right now, NRS 125.181 provides a streamlined process for those who have already reached a full agreement on all the terms of their divorce. Those parties can complete a joint petition signed by both spouses, submit a jointly signed decree to the court, and get their divorce relatively quickly without a court hearing, as long as all of the agreements make sense to the reviewing judge. This process encourages cooperation, and it's hugely popular with spouses who want to fast track a divorce. Litigants who are similarly in agreement to a child custody matter or to an annulment are often shocked to find out that they can't use the joint petition process, but must instead file a contested case regardless of their agreement. To get a court order for custody or annulment, one person must agree to be the plaintiff and file a series of forms to put a proposal together. The other person must agree to be the defendant and file a series of forms to respond to the plaintiff's proposal. And then finally, both people must complete their final agreed upon decree to turn into the court for review and hopefully approval. The number of steps required to accomplish a stipulated decree in the annulment and the child custody arena are far greater than that required for those who want to get a stipulated decree of divorce. AB 227 would make the same expedited divorce process available to those who are in agreement to an annulment or those who are not married but want to formalize a child custody agreement. In the bill before you today, sections 5 through 8 would make the joint petition process available to those in agreement to an annulment, and sections 14 through 19 would make the joint petition process available to those for child custody. All of the new proposed statutory language is based on the existing language in NRS 125 that lays out the divorce joint petition process. This bill would ultimately allow those already in agreement to get through their court case easier. It would reduce the amount of court resources required to file and finalize a case. And it would ultimately help litigants maintain a cooperative spirit to resolve their issue rather than introduce adversarial concepts for those who are not at odds with each other. So I thank you for your consideration of AB 227. I'm happy to turn it back over to the committee. Thank you.
All right. Any questions? Senator Orenshaw.
Thank you very much, Chair. And I just want to thank Assemblyman Cohen for bringing this bill. And I really appreciate all the work the Self-Help Center does. I get to meet so many people who are, I work at family court, but I'm not a family attorney. I'm a public defender. But I meet so many people who are, trying to get help from the Self-Help Center and would not be able to afford an attorney. So I really appreciate all the work that Ms. McDonald and Mr. Norman and Legal Aid Center does to help people down there. Certainly, I think if this becomes law, do you expect that there'll be less filings, in terms of those adversarial type filings, less hearings? It'll save judicial resources?
Sure. Stephanie McDonald, for the record, if I may. I would imagine that it certainly would. There are a number of litigants right now requesting this process, and unfortunately we have to steer them towards the adversarial route. They're typically able to complete their case without a whole lot of extra hearings and whatnot, but it does significantly delay the process for them, and it introduces possible barriers that a joint petition process would avoid.
Thank you, Ms. McDonald. Thank you, Chair.
Thank you. Other questions from members of the committee? Senator Stone.
And can I add, and I'm
Oh.
sorry, can I just add to be clear?
Please, go ahead.
Leslie Cohen, just to be clear, this is also for people, it's not just for the Self-Help Center and people representing themselves. It's also for people who want to hire counsel, to make sure that it's, plenty of people want to hire counsel, make sure they don't want to they don't want to go through the effort. They want to make sure it's done the right way. They don't want to have things rejected. But they still don't want to be adversarial with the other parent of their child or with their, soon-to-be former spouse. So they will come to attorneys, but it definitely will cost them less money. It will take less time in the courts. And so it will benefit everyone that way in that respect.
Thank you. Go ahead, Senator Stone.
Thank you, Madam Chair, and thank you for the presentation. I think this is a great way to spare a family the grief and hostilities sometimes that are shown in a divorce proceeding. But Jonathan, maybe for you, when you have these couples that come in and obviously the marriage is going to dissolve, there's a lot of issues that come up, the custody issues that this is trying to address, splitting an estate up, pension issues, even Social Security issues if they're elderly people. So before you get them before a judge to say, okay, we've got all of our ducks in order, we think, are they coming to you for a checklist to make sure that everything is done so they don't have to go back to court later and say, hey, we forgot about that issue. How do we deal with that now?
Senator Stone, thank you for the question. Jonathan Norman, I'm actually going to punt this to Stephanie because she is dealing with that and her team every day, all day.
Thank you, Senator Stone, for the question. Stephanie McDonald for the record. We don't necessarily have a checklist of sorts for people to walk through, but the forms themselves have a checklist. So if they're using the Self-Help Center forms to complete their process, they don't have to, because of course this is available to anybody, but the forms the Self-Help Center uses do include every variety of issues that would be mandatory for them to come to an agreement on in order to finalize the kind of case that they have. If they run into some stumbling blocks where they're not quite sure how they want to resolve a particular issue or another issue, we do have some great resources to help them learn and understand what the law has to say about that particular issue so they can come to their own conclusions, namely the wonderful partnership we have with the UNLV Boyd School of Law and their community education classes that explain divorce concepts, child custody concepts, community property, separate property concepts, child support in detail to help people understand what the law has to say and come to their own sensible agreement once they've gone through that process of learning about it. We also have Ask a Lawyer programs where we have volunteer pro bono attorneys who will meet with litigants and answer any questions they may have. We certainly encourage people to do that if they have questions before they sign anything, because undoing a mistake later is far more difficult than making sure it gets done right in the first instance.
Thank you, and I can just follow up. What are the requirements as far as being a Nevada resident in order to utilize these services? Can somebody from out of state come here and get a divorce here versus living maybe part-time in another state? How does that work?
Leslie Cohen, it's 6 weeks for jurisdiction for divorce.
And then, again, last question, and I do like the bill. Thank you for bringing it forward. What is the logical time frame that it would take two people that came to a consensus that they wanted to move forward with a dissolution of marriage? Are we talking about in a month's time somebody could actually have this all buttoned up and done?
Well, remember, so joint petition already allowed for divorce.
Mm-hmm.
So the bill isn't about joint petition for divorce, but if you're
With the
asking
custody,
about
yeah.
divorce, what I tell clients, if you're in agreement, it can be as, I've seen it 2 weeks if you're really thoroughly in agreement, but again, not really so much about the bill, but sometimes people will come in and they say, we're in agreement, we divided all the property, and they'll give me a list of pots and pans and couches, and I'll say, great, what about the PERS and the 401k? And they'll say, oh, we didn't talk about that. But if people are truly in agreement, whether it's a custody case or a divorce case, even an annulment case, which is a little different because the court's got different standards that the court's kind of determining. If they're truly in agreement and the court isn't very backed up, it can be a couple of weeks.
All right, Senator Krasner.
Thank you, Chair. Thank you for your presentation. So, kind of going off of what his question was, so, people come to you and say, okay, we're ready, we're in agreement, here's the pots and pans and the sofas we want, but the 401ks and the bank accounts aren't included. And what if one party doesn't even know about those bank accounts? Is it just too bad, ha ha, and somebody pulled the wool over somebody else's eyes? Or, is there somebody overseeing any of this? Thank you.
Leslie Cohen, no, but that's not really this bill. So there are ways in divorce you can continue to have a divorce where it is adversarial. If you have a divorce and you find out later that things were hidden from you, there is a way to come back to court within a certain amount of time. But yeah.
So quick follow-up. So nobody is overseeing this at all. If the parties agree, then that's what they agreed to. Is that correct?
Right, but this is just custody and annulment, so not really related to pots and pans or 401ks and that type of thing. This is just if the parents of a child want to come up to terms about, right, maybe a couple isn't married, but they want to determine how they're going to share the child after they're no longer a couple, and they know what they want to do, or with the help of the mediation center in Clark County at the courts, they decide how they want to divide up their time with their child. They can do that with this, or if they want to do an annulment. So people get married, and realize that they're related, or or someone was drunk and they got married. So but the divorce issue is not really this.
You're saying a divorce issue is currently in law, but it's not in this bill. This is just
Correct.
child custody,
Right.
and annulment fast track.
Right, just an example we were using because we already have joint petition annulments in
Thank
law.
you. Thanks.
All right. Any other questions from members of the committee? I don't see any. So thank you so much for your presentation. We will move to testimony in support of AB 227. Anybody wishing to give support testimony in person is invited up to the front in Carson City or Las Vegas. I'm not seeing anybody coming up to give support testimony. All right, then we'll go to the phones for support testimony on AB 227.
Thank you, Chair. We have no callers to testify in support at this time.
All right, then we will go to testimony in opposition. Anybody wishing to give opposition testimony? I don't see anybody in person, so we'll go to the phones for opposition testimony on AB 227.
We have no callers to testify in opposition.
All right, then we'll go to neutral. Anybody wishing to give neutral testimony on AB 227? I don't see anybody coming forward in Carson City or Las Vegas, so we'll go to the phones for neutral testimony on AB 227.
We have no callers testifying in neutral.
All right, then that concludes the testimony on AB 227. Unless you have any closing remarks, that will conclude the hearing on AB 227. I will close the hearing and go to the only other item on our agenda, which is public comment. Anybody wishing to give public comment in person is invited to the front of the room in Las Vegas or Carson City, but I don't see anybody, so we'll go to the phones for public comment, please.
We have no callers in the queue for public comment.
All right, then that brings us to the end of our meeting. Tomorrow, I am going to ask our members to show up about 10 minutes early at 10 to 1 so that we can take our committee picture. For those of you joining us in the audience, the doors might not open until 1 p.m., so we can take our pictures, and then we will have a normal meeting tomorrow. Same time, same place. All right, until then, we are adjourned. Thank you.